So it is time to start the third panel here in the main stage. For those of you who are watching on the internet, hello. We're going to do a round of questions at the end. Please make sure that a microphone comes. I'm going to be running around like Phil Donahue. So yeah. That being said, this word, discriminnovation, is trying to be a little bit of a tongue-in-cheek for a very serious conversation. We are very fortunate enough to have Cindy Conti-Cook coming back to be on this panel that we continuing the conversation that we had last year. Rashida, Rashida was also on the panel. And sandwiched between them is Councilmember Jimmy Vacca, former city council member, now professor at Queens College. And what we want to talk about this conversation, how many of you know about New York City's open algorithms law? Raise your hand. Great. Well, for those of you who don't know, one of the things that has come up is the fact that there are these crazy things that are called algorithms, right? Artificial intelligence, and it's powering a lot of our world. And Councilmember Vacca was able to introduce a pretty forward-thinking piece of legislation that we were honored, BetaNYC was honored to give testimony at in support of, and New York City has the unique opportunity to continue leading the way in regards to digital government. We have more or less a 24-month time period for the city to work on this task force to think about like how to pioneer and make sure that our government is transparent, responsive, and ensures justice through digital government. And so it's a real honor to continue the conversation that we started last year around discriminnovation. If you want to use that as a hashtag, I would love that because it's something that I would like other cities to be discussing all in one long swoop. And then what's the hashtag for the
NYC algorithms? It will be up there.
All right, well, let me move this over here. So that being said, there's two additional hashtags for this panel. Internet, please tweet at home. And I'm going to hand this off to Rashida from NYCLU or NYCLU. And she's going to walk us through everything, right?
Yep.
Okay.
Or not. No. Hi. So I'm just going to give a brief intro so that way we all have like a baseline understanding of what we're talking about and then pass it off. And we'll each sort of cover portions before it opens up into a Q&A. So today we're talking about government use of algorithmic-based systems. And in the most simplistic terms, an algorithm is a series of steps or instructions that can be used to perform a task or make a decision. And most of the algorithmic systems that are used by the government and that we'll be referencing today are considered black box algorithms. And that often means that we don't understand their internal mechanics, so we don't know what factors they're using. We don't know the weights of those factors. We don't know the data that it's trained on. And we also often don't know how much deference that city employees are giving to these systems to either make decisions or inform their decisions. So today we're going to sort of go into more detail about the various policy and legal concerns that come up when talking about these government systems, because it often raises concerns about discrimination, undermining due process, and then really forces us to think about like what is fairness when you have systems that are often undermining both legal principles that we traditionally think the government is upholding, or just societal principles that we think are often going on. So today, Cynthia Conti-Cook from the Legal Aid Society is going to be giving us greater insight into algorithmic systems used in the criminal justice context and parsing through some of the legal and policy questions that are coming up. Former council member Jimmy Vacca is going to give us context on this law that passed in New York City and sort of what happened to get it across the finish line last December. And then I'm going to wrap up just sort of talking about the challenges and opportunities presented by the task force and some of the advocacy work that's going on in New York City. So with that, I'm going to hand it off to
Great. Good afternoon, everybody. That's right. Okay, so there's one person here. He's sitting over there. Good afternoon, everybody. There you go. So my name is Cynthia Conti-Cook. I work at the Legal Aid Society, which, among other things, is the primary public defender in New York City in all 5 boroughs. And I want to talk with you today about 2 specific types of risk assessment instruments being used in the criminal justice system. And when I say risk assessment instruments, do people have general familiarity with what that means? No? Okay, cool. So just to give you an overview, there are risk assessment instruments used in various aspects of the criminal justice system across the country. They are used to determine someone's potential risk of flight, someone's eligibility for programs, whether someone is eligible for what in New York City is called a supervised release program. In some states, not in the adult system in New York State, but in some states, they even use risk assessment instruments to determine sentencing. So whether someone should be sentenced to an incarceration or sentenced to probation, for example. Prisons use these to classify whether someone should go into a minimum or a maximum facility. The probation department uses these to determine whether young people who are charged with offenses in the juvenile system should be getting pretrial detention or what type of sentencing they should get, including in New York City. Probation officers can also use these to determine what level of services people might need. They are used to determine parole release, whether someone should be eligible for parole after serving their time in prison. Parole supervision is also another way that they're used to determine what level of services they might have a need for in parole. So these systems are built on data sets that have previously accumulated in the criminal justice systems, and then they introduce machine learning in most instances and basically ask the old training data, right? The question of what is likely to contribute to this person's risk of rearrest, to this person's risk of flight, to this person's successful rehabilitation. And based on that definition of success or that definition of the outcome that the training data set is asked about, it pulls the factors that are most likely to contribute to that person's either risk of rearrest or whatever the risk or whatever the outcome that the algorithm is asking about. So I'm going to talk to you and explain this a little bit more through a comparison of 2 different types of risk assessment instruments being used in New York. And through that, I hope that you can begin to appreciate how important it is for us to have more transparency about these instruments and more accountability for how unfairly they treat some of our population. So the flight risk assessment is not new. The flight risk assessment has been used in New York City's criminal justice system for decades. When you have been arrested, you go through the system within 24 hours in New York City, theoretically. And at the end point, right before you meet your attorney, you're interviewed by a criminal justice agency representative who sits down and asks you questions about your demographics, about your employment, about how long you lived at your address. All questions are calibrated to determine your risk of flight. You can see, this is the bottom of the form, that there are 8 questions which have scores, and those scores have a total. Former Councilman Vacca, if you could just, if you can't see it, it's right behind him.
I didn't talk yet. Off the panel.
The total points are 3.
When I'm finished, but not when I start.
So you can see that the total points are 3 in this example. And you can see how the questions and their corresponding points are visible, right, on the score sheet. It's something that the defense attorney, who would then be representing this person, can actually look at, see how they're being scored, and then begin to formulate arguments. This person's score of 3 indicates in words to the judge, right, that this person is a moderate risk for ROR. That means release on own recognizance. So in other words, moderate risk for ROR says to the judge, you might want to think about setting bail, right? And as we perhaps know, but there's a huge crisis and controversy about setting money bail across the United States. But that is a different panel. What does it mean? What does it mean to be a moderate risk of flight? Well, mathematically, it means that you have a 14% chance of not coming back to court. Another way of saying that is that you have an 86% chance of coming back to court. But that is not what is being communicated to judges in this tool. However, it's something that the attorneys could potentially argue because the Criminal Justice Agency publishes its score sheet and the way that it comes to its decisions. And it has, you'll notice, a gradation of outcomes. This is not a yes, bail, no release. It's not a yes-no system. It's a graduated level. So there's low, medium, high. That'll become important later. And again, CJA does publish the sort of score sheet and how it comes to that calculation. So in this person's case, you can tell if you look at the weights, so what's in these columns are the weights, right? You can tell that what question has the most impact on whether you're going to be getting bail set or released and going home. The one that says 5, right? Okay, so whether you have a prior warrant. And you notice that it's just prior warrant, yes or no, right? So if you've had 10 prior warrants, it doesn't matter. If you've had only 1 prior warrant, it doesn't matter. If you had 1 prior warrant and you came to court the very next day because that other day you had a child care emergency, that doesn't matter. So this question is really problematic, right? But because we know in this person's example that having that question answered yes is going to cost them the most amount of points here. You can see they're deducted 5 points or whatever, they're added 5 points, but the result is that they have 5 points deducted from their final result. But it's because of that question that they are a moderate risk for rearrest. But at least, right, the defense attorney with this tool can say to the judge, Judge, that prior bench warrant, that 1 prior bench warrant was based on a child care emergency. They came to court the very next day. And so this type of transparency, at the very least, I'm not saying the system is perfect or that this tool is perfect, but at the very least, we can construct and articulate arguments around how the decision is made and argue a few things, that the judge can disagree with the system, that the judge should consider it 86% likely instead of moderate risk, whatever that means, and that the things used to determine this score are actually not logical conclusions of what this tool is supposed to promise, right? Which is risk of flight in the future. And so I'll come back to this actually. I want to compare that to supervised release. Now this is a new program that's only been introduced since 2015. And this program is different from the previous risk assessment instrument in significant ways. When we have a client who is being evaluated for supervised release by another nonprofit agency, we just find out yes or no. Client is in or out. We have been given a score sheet. We know what they are generally scored based on because we've seen this. So we know that age is going to be held against you. We know that if you've been convicted of any drug crime in the last 9 years, and I don't know if any of you have learned about how the drug wars have contributed to mass incarceration, but some communities are policed very differently than others, and the collision frequency with police officers for some people are very different than for others, even when drug use is generally reported pretty evenly throughout society. But drug conviction in the last 9 years is going to be held against you. So we know these things are what people are generally being evaluated on. But when the person from the program comes to us, the defenders, and says this person is in or out, we don't get to see the score sheet. We don't get to argue with them and say, hey, they shouldn't have this held against them, you know, or this drug case was sealed, or something like that. We don't have that opportunity. And this is the trend that a lot of, as Rashida called them, the black box tools are going in this direction. So if you compare the two, right, graduated outcomes, low, medium, high, as problematic as they are in sort of the way they're described, versus in or out. A score sheet that's disclosed versus no score sheet. A score sheet that can be argued against versus no opportunity to argue. And a score outcome that the judge can override versus something the judge can't override at all, right? And so it's because of these problems and the way that a lot of these tools are operating, specifically in this context, in the pretrial release context, that we really need the type of transparency and adversarial testing, and testing not only for accuracy, but group fairness, right? And so to go back to the controversy is really, in the criminal justice system, how are these tools going to be fairly used? And these questions about fairness and testing tools for beyond utility and accuracy, because their accuracy is really only the ability to predict how the system will work in the future. That isn't the same thing from our client's perspective as the ability to understand the probability that an instrument is going to find a false positive, to inaccurately identify someone as a risk when they are not. And so that is the nature of the controversy, and that applies across all systems. It includes the criminal justice system, but also, if you saw an article in the Times a few weeks ago, it applies in the foster care system, and whether ACS is going to remove a child from a family. And it's used to determine benefits, education placement, and across many, many different agencies, which is why, and I'll segue to former Councilmember Vacca, which is why we really need the type of transparency that his bill takes a step towards.
Thank you very much.
I did something. Just a slideshow. I can end on that.
Okay. All right. Well, with that, we can actually have you sit. Oh, you're mic'd? Can they hear you?
I don't
Yes.
know. Put this thing on me. I don't know.
Huh?
I think I need a microphone, not just this.
Try both.
Yes, right.
Okay.
Okay, I'll let you speak. Can I speak over there?
Yeah, if you
Oh,
want.
all right. Hello, everybody. How are you? I'm former Councilman James Vacca. I haven't been a councilman for 7 weeks, so I have to start getting used to saying that I'm no longer a councilman. When you were there for 12 years, that title just sticks. But it was my pleasure to serve you in the council, and I was chair of the technology committee, as many of you may know. But one thing that I did manage to get done before I left the council was that we enacted the first in the country algorithm legislation. And you've heard much about it today. I came at it from a very community type point of view. Over the years, I always was intrigued with how the police department determined how many police officers were assigned to individual police precincts. And I discussed it many times with various commissioners. So I represent the 45th precinct. And I always said, how did we get 190 officers? Why not 191, 194, or 300? And I was basically told, well, your crime rate is low. I says, no. There's got to be data that you use and that you weight and that you consider to determine what that number is. I would like to know. And I was never given any information. I was never told. I was never given anything that I can review or evaluate. And the same was true of other neighborhoods throughout the city of New York. That always galled me. Something else that galled me is when a parent would come to me and a parent would say, Mr. Vacca, my kid is going to high school and he put down 7 choices and he got choice number 6. But the kid next door got choice number 1. How did my kid get choice number 6? I could not answer the question. You call the Department of Education and they'll say there was no more seats in choice 1, 2, 3, 4, or 5. That's the explanation you receive. But then how did my neighbor get choice number 1? So what I was looking for was transparency and accountability, because people are entitled to explanations when government makes decisions that affect their everyday life. And that's where we have to know what data goes into the algorithm that determines how government makes a decision when government uses an algorithm to do so. We don't have that information today. I sat on the city council for 12 years. We have budget hearings. Now, don't forget, of course, you all know, obviously, we are a representative democracy. As a representative of the people, I'm supposed to go to the city council, and I'm supposed to have oversight power over the city budget. And I'm supposed to question agencies to see how they spent the money. But the reality is, I don't know any of the budget formulas that go into the decisions city agencies make on how to spend the money. They'll come to the city council, oh, we need more money. They always want more money. But there is no way for me to know what algorithm, again, or data went into allocating the money that they received for the purpose they received it. So how do we in the council really do budget oversight and adopt a city budget when we don't have all that information? Moreover, how do we then go about evaluating performance of these agencies? How do we then go about evaluating program effectiveness when we don't have the basic knowledge as to how the information that went into the data and algorithm determined what the allocation was, how and where the money was spent? Now, we did hear today a little bit about policing, and I'm concerned about policing too. Predictive policing is now going on in Chicago. As many of you may have read, Chicago had a very bad issue with murder. They're now looking at predictive policing. I'm concerned about that. Chicago would want you to believe that their murder rate is down, which I'm sure you cannot fake murder rate. So I would look at those stats and say, well, maybe murder is down, and then I would assess, well, why is it down? But on the other hand, does predictive policing go so far as to indicate that youngsters, because their parent had a criminal record of some type, that those youngsters are more likely to be in the criminal justice system, and therefore we should have law enforcement on their toes when it comes to that kid, rather than saying, well, we have a kid here who may be falling through the social cracks. Let's intervene early in the school with counseling services and related services to make sure that we pick up where maybe the parent is not doing as well as we would like that parent to do. So how do we use these tools? We have to confront the reality that we're in a technology age. Technology will be used more and more frequently. Many times we will not even know that it's being used, yet we should. And yet we should know how it's being applied. From a social point of view, there should be an accountability. So I introduced algorithm legislation, and I would be negligent if I didn't mention Zach Hecht, who was my legislative director in my final year at the council, who did a fantastic job. And we right away had objections from everybody, but we got a bill passed. And it's the first bill in the country. Other cities are now looking to replicate what New York City has done. Other cities are looking at what we do, because, as Noel indicated, we have an 18-month to 2-year timetable where the agencies in the city must now come forth with a plan of action and a program designed to deal with the issues that I've raised today, namely accountability, transparency, evaluation. Those are the 3 cornerstones of my algorithm bill. So they have a reporting period. They have the task force that the mayor was ordered to form must be in place by mid-May, and then from that date they have 18 months to make a report. And I'm no longer in the city council, but I'm going to be very much interested in this. And that's why when I heard about this forum, I wanted to speak, because I want you to be interested in this. I want you to know that this is coming, because we need voices and we need advocacy people in the months ahead to make sure that they're vigilant. Because this, when I think of the future of our city and of other cities and states around the nation, I think of very little that's as important as this, because we don't want government at any point to be a runaway train. Knowing what we know about Washington, especially today, sunlight is a good disinfectant. And at every level, I think that sunlight often is what people want and they're entitled to. People are entitled to explanations, not just vague platitudes. People are entitled to know why decisions are made and how. And people should be entitled to contest those decisions. The word I use is appeal. But if not a formal appeal, how do you contest? Well, it's difficult to contest if you don't know how the decision was made. Knowledge is power. And I look to empower people through this legislation. So I thank you very much for having me. And please, I hope that you'll join me in watching this in the months ahead. Thank you.
Tough act to follow.
I know.
I think I can talk down into this. So I'm here to wrap all of this up in some cohesive way. So I think the first thing is to explain this point that we keep making, that this legislation is the first in the country. It is the first bill in the country to take such a comprehensive look at government use of algorithmic systems, and that there have been pieces of legislation that were introduced. For instance, there was a bill that passed last year in Massachusetts that's specifically looking at risk assessment tools in the criminal justice context. And there's been a few other states and localities that have passed legislation, but most of them are looking at very specific systems, and often those pieces of legislation are after there's been some atrocity, then public outcry and media attention about the issue, and then this very myopic focus on one system, ignoring the fact that similar systems exist elsewhere. So this bill is really important in that it's recognizing that there is a pervasive use of algorithmic systems, and we kind of need to understand all of the uses and really gauge these questions of, are there some uses that should be completely not used? Are there some that should have certain checks and balances if they're used? And are there some that we need to figure out as a country and we may not fully understand? And it's also important because I think, as you can hear from the other great speakers on this panel, there are real concerns about the use of these systems, in that there are a lot of questions about their accuracy. We know specifically about some systems and their tendency to amplify and reinforce bias that exists in our society, but it's also that government is forced to make a lot of difficult decisions. So if you have an agency that has the responsibility of determining how to use very limited and often shrinking resources to benefit a few, that's a difficult decision to make. And if there can be a technological solution that can be value added to that decision, then we don't necessarily want to deter it, but we also don't want those systems to reinforce the problems that we know exist. And in general, the task force presents a lot of opportunities. I'll focus on that and then go into the challenges. So one, as former Councilmember Vacca
Happening to you too.
Mentioned, is and I've already said it, that we know that there is pervasive use, but we don't know where these systems exist. And one benefit of the task force is that they should be able to enumerate where these systems are being used and how they're being used. But also the task force is grappling with a lot of difficult questions, like how do you redress harm that may be caused by a system, and even more difficult questions like, if we know that the system was the cause of a harm, but that bias or error that resulted in that harm is just part of a larger systemic issue like poverty and racism, then how do you really redress that harm when we know it's just compounding the problems that we either choose to ignore or not address in society? So I think there's a lot of very difficult questions that we may not always know the answers to, that the task force is going to grapple with. And then also some more technical questions of how do you archive these systems to go back and look? How do you ensure that researchers have access so we're not just depending on agency employees who may not have all of the expertise in the areas necessary to question these systems? So it's a lot of really tough questions that I think they're going to have to answer, but important ones that will result in the type of change that we want to come out of this process through recommendations. But it's also not all perfect in that there's difficult questions to deal with, but also assuming good faith in the whole process. So one of the largest challenges that I think is going to happen is that all of those questions that I just outlined that the task force has to grapple with, and also the enumeration of the systems that are being used, is dependent on cooperation of all government agencies. And that's the assumption that all government agencies will comply, and there's definitely a lot of agencies that are welcoming this process, but there's also a lot of agencies that don't necessarily want to be transparent, or there's too many bureaucratic barriers that would make cooperation very difficult and may not be the cost-benefit analysis that they want to, that would permit cooperation. So there's definitely some challenges that the task force will face. And then to just end, there's a bunch of work that's happening around, so it's not simply this task force is going to happen and then recommendations will come in 2019, but there's also a lot of advocacy that's happening right now. Legal aid, our NYCLU and the ACLU, as well as the host of this event, BetaNYC, is working with a lot of researchers and organizations to ensure not only the efficacy of the task force, but ensuring that this issue stays in the public discourse. So we had up the hashtag, and I'll say it again, but hashtag NYC algorithms is what we're using to sort of make sure you stay part of this conversation. So that's one place to look for some of our work, but also we're going to be doing a lot of work to not only ensure that the task force is effective, but also raising things that are important to us, like, are there uses that should just be off the table? And how should we be talking about that? How should we be engaging communities that may be affected by these systems with, and not have to wait from 2 years from now to see what the best solution is? So there's definitely a lot of work to be done, both using this process and afterwards. So it's really important for you all to stay in tune, add pressure to the administration and necessary officials to make sure that something happens, because I think this is a great opportunity for New York City to be a leader, but it's also obvious from this panel that these are difficult questions and issues that we're grappling with, so we want to make sure that we're doing it right, especially if we're going to be the first. And I'll stop there. And we'll open it up for questions. So are we going to pass the mic?
Hi, my name is Will. I'm an organizer with the Democratic Socialists of America in New York. And thanks to NYC's open data around campaign finance, we were able to determine that the replacement chair of the City Council Committee on Technology, Peter Koo, along with Kalman Yeager and others, took not insignificant funds from the PBA and the DBA police unions. And so you might expect that the police interests would have influence over the future of this legislation, as well as some of the special interests that you mentioned, as well as agency pushback. The mayor's office had some issues with the initial legislation at the initial hearing. So I'm wondering what we as the public can do to organize and to push and to exert our own influence over the council and over the city to make this. So sort of along the lines of what you were speaking out, if you could expand on that.
Well, if I could say, whenever the city council assesses legislation, there's a multitude of interests that weigh in. I would think that in the months and year and a half ahead, we're going to hear from many, many interest groups who are going to push the council in many different directions. I do tell you that this council, I think, is a very emboldened council. I think it is a very independent council. They were committed to the legislation I passed, and I do think that they will be independent in reviewing the facts. Where is the role of the average citizen? Well, you also have pushback power, and you have to be in the room. And that's, to expect that all the stakeholders on any given bill are going to agree on how to proceed is just not realistic. But you have to be in the room, and you being in the room and others being in the room means, hopefully, the council will be able to get a consensus as to how to proceed. Now, the administration is an important partner in this, but if the council in a united way starts to say that they're not happy with the recommendations that come forth, then I think that we can build upon that.
Yeah, and just to add, I think there's like 2 pressure points. One, I think there's public pressure to ensure that the administration ensures that agencies are being cooperative, because I think you said, I've said, there is a concern. Like there's both legitimate and what I would think is illegitimate reasons for why an agency may not want to be cooperative, but it is on both the administration and the city council to push these agencies to actually comply so we can ensure that whatever the task force reviews results in useful recommendations. And then I think if you're dealing with a worst case scenario where the recommendations are kind of useless, then I think there's, or even if they are good, there's going to be a certain level of advocacy and public pressure to ensure the right recommendations or right solutions are adopted. And I think what worst case and best case scenario can function in two ways, where if the recommendations are perfect, then making sure the city council actually acts on them and they're adopted. And then in worst case scenario, it's making sure that both the advocacy and research community are there to sort of point out what the best approach is and then pushing for the better approach to be adopted.
I just wanted to,
I'm sorry.
I was just going to add, just so that there is no confusion, New York City is using predictive policing. They have been piloting HunchLab and PredPol and Palantir, which are companies that have created risk assessment instruments for predictive policing uses, but now they've come up with their sort of own organic brand, which you might have read in the news referred to as precision policing. So I want to be clear that there is predictive policing being used in New York City, even though if it's not by one of the industry companies. A really great book to use to educate yourself more about why predictive policing is so problematic is Andrew Ferguson's The Rise of Big Data Policing. And also, I would recommend following the Brennan Center's litigation against the NYPD for transparency around their communications with Palantir and other predictive policing companies that they had in coming to the decision they were going to create their own tool.
Okay. If I can just tell you where one area exists where I think the city is its own victim, and that has been the assessment of real property in the city of New York. And there is a lawsuit now pending because, again, no one knows how the city arrives at how much a piece of property is worth. And people found out that very expensive brownstones in Brooklyn have a real estate tax level or assessment level that is much lower than a small attached two-family house in the North Bronx. So there is a disproportionate tax burden. There is a real estate assessment system that is the most impossible to figure out. No one knows what goes into the whole assessment determination, but it's now in court. But this is something that the city has known for years that they have to address, and they've not addressed it. We have people, senior citizens and immigrants in low-income and moderate-income areas, such as the area that I used to represent in the Bronx, who are paying a disproportionate amount of taxes, while those who are very rich and very well off, in proportion, pay much less. That is discriminatory. And we have a right to look at that formula, understand it, assess it, evaluate it, and move on and do something about it. And we've not for years now. It's too much of a hot potato for anyone to attack. Well, the courts may be moving the needle on that based on their decision that should be coming down in a year or two, I would assume.
So we have one question here.
Yep. So first, I just wanted to applaud you, former councilman, for proposing the open algorithm law. It's great. It's, as you're talking about, really important to know what kind of data is being used for decision making. And it can also highlight injustices in the system that have been pervasive for years. The risk assessment sheet that's being used in, the pre-trial judgments, that's existed for a long time. It's just, innovation in tech and data and sharing has highlighted some of these problems. So it's not necessarily a quantitative problem about the data, but the qualitative problem about the kinds of questions that governments have been using to, make decisions or to influence law. I just want to take a minute to highlight that the great state of New Jersey, of which I'm from, has eliminated cash bail for minor offenses, and they are moving entirely to a risk assessment tool, which is not perfect, but it's really helping to reduce injustice in the legal system, because now you're not keeping people in jail because they cannot pay, they cannot afford bail. And it's also minimizing people who are, pleading guilty just to get out of jail, even though they may not be, which then is now on their permanent record, and they can't get a job. So you may want to look at New Jersey's most recent law that's done that. And in conjunction with the open algorithm law, I think, there's a lot of learning to be done, like across state lines. But that law was really brought from the ACLU, and then New Jersey's prosecutor, I don't know what the division is, but it got the state prosecutor on board, the defense, then other grassroots organizations, human rights organizations, and then the governor, Chris Christie. It's like the one good thing he did was he agreed to put this on the ballot, and then New Jerseyans were able to vote to support that. So it was a collaborative effort. So I would just ask, have you looked at any of that? New Jersey's recent system, and they're minor gains, like nothing's going to be a solve all, but I'm just curious to get your feedback on that, and if you feel like that's something you could implement. Sorry.
Thanks.
I've certainly looked at the New Jersey risk assessment instrument. So New York is really different than New Jersey in one really important aspect. Dangerous may not be considered when deciding whether someone will be released on their own recognizance or have bail set. In this really important aspect, we've been able to resist risk assessments being used in the bail determination system the way that they were implemented in New Jersey. And what I would say is that there should be a moratorium on the use of risk assessment instruments in the criminal justice context for a few important reasons. The most important reason being that all of the data that is used in order, whether it's in predictive policing or whether it's in the criminal justice system, in the risk assessment instruments about pre-trial detention, they are all based on police and criminal justice system data collectors. I'm talking about police officers, prosecutors, judges, and correction officers. Those are not data collection experts. They are not sitting down with people and doing a 90-minute assessment based on a 42-question survey about someone's actual risk of re-offense, or someone's actual risk of flight, or someone's actual risk of dangerousness. And because we're relying on non-data collectors, on non-trained specialists, in order to make really important decisions about people's liberty, I would never recommend using any risk assessment instrument to decide whether or not someone goes to jail or goes home.
And I just wanted to add another concern is the proprietary issue, and that often, we talked about how the fact that some of these systems are going in-house and being developed by the agencies themselves, but often they're coming from third-party vendors. And often, and this is why I started off the beginning sort of saying these are black box systems and that we don't understand the internal mechanics or even the factors that are being used. And often that information is considered proprietary data. So that's actually what raises some of the due process concerns, because if you don't fully understand what the system is using to decide that you should be receiving bail or you shouldn't, then how can you really challenge it? And that's, and actually Palantir is a great example, because there ended up being a huge proprietary dispute about their system that they supplied to the NYPD, because when the NYPD transferred to create their own system, they said that Palantir didn't give them all the analytics for them to run their system, and Palantir said they did, and everything that they didn't hand over was proprietary. So you also end up in these systems, or in these situations where if you start with a vendor system, mostly because most government agencies don't have institutional resources to build their own systems at first, and then you shift over to your own, then all of the sensitive data that's being put into the system, and often like flawed data, I'm like trying to narrow in all the problems here, are being lost, and then you have like these new systems that are like slightly corrupted because you don't have the old data. So it's just like a number of variables that contribute to risk assessment tools just not being a perfect alternative. So the same in that, like, I'm coming from the ACLU, so those were our partners that were working on that. And it's not to discourage what happened there, because it is an important reform that happened in New Jersey. But I think simply relying on risk assessment tools, or really just any algorithmic system as the full alternative, is not perfect, because we know these systems are flawed. And when you're not allowed to interrogate the systems, there isn't enough accountability to ensure that problems can be corrected, then we're just reinforcing the same problems, but saying they're technological solutions and not really discussing what's really going on.
We had 1, 2, and then where are the other questions? 3. Any other questions that are around? Okay.
So the General Data Protection Regulation, which applies to all EU member countries, has a right to explanation, and that goes into effect in 2 months. And because the European Union is a pretty big market, I imagine it's going to impact a lot of the vendors that we're also talking about. So I'm curious if that is something that's being observed or tracked as far as how much that's going to have an impact here in the U.S., even though we don't have a national law. And also, I think the point on proprietary systems or black boxes, I think it's really important to make the distinction around like intellectual property protection versus black boxes, because the technology itself is intrinsically a black box, and machine learning deep neural networks, that like those, no matter how, like, if you ask Google or whomever to open up like their their deep learning, their neural networks, like you can look in it, but it's like it's not intelligible, right? So I think, is there a way to make the distinction where there's the technology itself is a black box and there's no way around that other than just recognizing that's the reality of the way that technology is moving, and using that as a point to offer appeals or other alternatives around that? Because in the medical community, you're using a lot of machine learning to diagnose things, and it's like you can't explain that, but you can verify it independently in some other way, right? So what are the ways that we can still work around that while taking advantage of it where it's applicable?
That's a lot of questions.
Yeah, I think about the EU, which is where we started, I think, I believe what I understand from briefly looking at that is that it's focused much more on privacy questions.
It includes a right to explanation.
Right, but less so on questions of group fairness. And so I don't know that the European Union's, we'll see, but I don't expect that it will solve the problems that we're talking about today, which is discrimination that is baked into these systems. And so like
I can point you to the specific legal language. I think you might be wrong, but yeah.
Well, I'm happy to be wrong.
Can I just
Yeah.
There may be some benefits. Some of the researchers that is in the advocacy group that I mentioned are people who actually have been helping a lot of the EU countries with implementation, and then each of the EU members have to come up with their own sort of compliance systems. So it's possible that that process can incentivize vendors to do. I'm just like very cautious about incentives of vendors, but it is possible that that process can influence what's going on here. But even though we're 2 months out from implementation, it's still a few steps that need to happen in order to even gauge if that's going to happen. So some of our advocacy work is trying to figure out, okay, what are they doing there, and how can we use what they're learning there, especially around the piece of the right to explanation that may be useful for us. But I don't think everything in GDPR is necessarily going to translate to reform here. But okay, second part.
Remind me of the second part.
The black box of the technology itself isn't something that you can necessarily regulate around, right? It's the intrinsic to the way the technology works,
So what's the question?
So basically, like, does that mean that you outlaw that technology writ large, or is there a way that you identify that's the case and provide alternate sort of, routes around it if it's potentially problematic?
It depends what context you're talking about, and right, what questions are you asking the data set, and how hard have the data scientists who are building a tool looked at the data collection and how accurate it is, and whether the people that are collecting the data, maintaining and organizing the data are actually invested in using it for that purpose. Right now, in the criminal justice context, the people who are collecting and maintaining and organizing the data are not doing that for the purposes of data scientists being able to create a predictive tool, even though that's what they're currently using it to base on. So I think that the data science community needs to have a lot more conversations with stakeholders who maybe have different outcomes in mind other than the accuracy of predicting policing, right? Rather than just predicting crime or purporting to predict crime. And so I would encourage data scientists to think more closely with people in the system who can talk about the problems of data collection in the criminal justice system. So one really great example of this was Patrick Ball, who was on this panel last year, did a study where he took the Department of Health self-reported data on drug use in Oakland and found it really evenly distributed throughout Oakland, right? But when he took the data from the Oakland Police Department about drug possession, it was concentrated in just a handful of areas. There's a data collection problem. And so I really think that the questions about whether we should be outlawing black box machine learning tools in the criminal justice system, yes, absolutely, because we haven't figured out what data we want to be collecting. And honestly, do we as a society really want to collect accurate data on crime? That would require a lot of surveillance.
And I also think there's questions about implementation. So and like deference in decision making. So in the example in Allegheny, I think I'm saying that right, I think County with the Child Protective Services, that system is only used at the initial intervention level. So if they're deciding whether or not a family should be investigated, but the information collected cannot be used by caseworkers or judges later on. And I'm not saying that that system has its own flaws, so I'm not saying that's the right approach, but I think you can also consider what are the entry points that should be barred from using these systems and where could they be useful understanding the drawbacks, and then also questions around deference. So if a government agency is using this, is it only to inform a decision, or are they actually completely relying on the output of that system to make a decision? And can there be parameters put in that's like only 10, the thing is how this works in reality is a little bit difficult, but like really saying how much deference or even no deference that should be given to the system. It's just more another input, but can't be used to decide something.
If I can say one thing, in all the discussions we had concerning this bill, and now that I listened to this discussion today, I want you all to know one thing that I have always stressed. Whatever we do must be understandable for the general public. We have already left many people behind when it comes to technology. Many of our poorer residents have unequal access. Many of our immigrant families, many of our senior citizens have been left behind. So when we establish policy, I want it to be public, I want it posted, but I also think that we face the challenge of making it clear to everyone what the policies are in an understandable way. And that's how we have to proceed going forth. Cannot be above their heads. We can't lose them as part of the process.
Great. Well, Jimmy, you just answered two questions that weren't even going to be asked, right, or that they were going to ask them, and that's fist bump, dude. All right. Who has other questions? All right.
Hi. I think one of the assumptions that we've seen here is that people are entitled to know what decisions are made and contest or appeal those decisions. And I agree with that, and I think that's a normative assumption that we agree with. But I'm not sure that on a procedural and legal level, there is in fact that, that is a normative basis. And so before these processes were automated decision systems, they were still decision systems with certain inputs and outputs and certain areas of discretion and decision points. And so it makes automating the tools a different process and a different question for appealing them.
it,
Right.
Internet.
well, juries don't have to explain their decisions because they're making decisions on the facts only. But when you are automating decisions that usually would be made by a lawmaker or a decision maker like a judge, sort of a lawmaker, unelected lawmakers, a judge does have to make their decision in a way that is clearly able to be reviewed later. They can't just sort of make, in theory anyway, I'm not saying that they don't, but they are not supposed to just make sort of conclusory decisions. They're supposed to explain their decision-making process in accordance with the law as applied to the facts of a specific situation. And if we, as the advocates in the room, think that they have done that in a way that is wrong, that is not in accordance to the law, which in some ways is just another sort of algorithm, we can appeal that decision and have a different decision maker review that. Now, in the context of bail decisions, we have been able to march into writ courts and say to another judge, this decision was made poorly. It was not made in the correct information. They considered dangerousness and it wasn't supposed to be considered, something along those lines. We can have that decision reviewed because there has been a record that has been made. And sure, humans are not perfect decision makers. I don't think any of us would say that. But it is a thought process that is required to be explained. And that's what we really lose when we are using an automated decision process. Now, in the defense context, in the criminal defense context, you have confrontation rights. My clients have the right to interrogate the evidence that's being used against them. This model, by just sort of making the decision, especially if the judge is relying on it exclusively, it's really removing our client's ability to interrogate the decision maker. And another example of this is in the context of like a juvenile sentencing hearing, the probation officer who would be making the recommendation about whether someone should be detained as a young person, as a 16-year-old person, or whether they should get probation or whether their case should be dismissed and they can go on living their life and go to school, that decision maker is usually put on the stand. And the attorney for that young person can cross-examine the probation officer, the decision maker, about how they came to the decision of the recommendation. And based on that cross-examination, on testing the evidence, on testing that examiner, we can make arguments to the judge about whether or not that recommendation should be followed. When the probation officer brings in a tool and says, well, the tool says, so what? We can ask questions about how the probation officer put the scores in, and whether they came to the right score, but we really can't interrogate the tool. We can't interrogate the tool and ask whether the young people that it tested its accuracy on were like the young people in New York City. And now this is a tool that's used around the world.
Wait. So can I just also want to say that I think most of our comments from the beginning have been challenging a presumption that we never stated, and that's the fallacy that these systems are objective. And from the beginning, I think we didn't say that that's a presumption that's often made, but it is. And that's part of the issue that comes up with deference, in that it's like, well, the system isn't going to have bias, so of course the system's going to be better. So that's, I think, something that obviously, like, we're advocates, so we're leaning in a certain way, but I think that's one of the presumptions that also your comment is getting at, in that, like, these are subjective systems, so they do need to be questioned, and when you don't have access to that information to question, then there is an imbalance.
We have 3 minutes left on this panel. You're good? Okay. This is the last question right over here. Hopefully the microphone doesn't die.
Hi, my name is Vianney. I just wanted to piggyback. I think, is that Philip over there? Yeah, I really enjoyed Philip's distinction between like the actual algorithms, again, being opaque. And I was but there's also potentially, even though we might not be able to, have an intelligible.
Knew that was going to happen.
Intelligible. Speaking of intelligible. So even though we might not be able to verbalize what an algorithm is doing, to a certain extent, I was wondering if people are doing research around being able to have some transparency around, like, given certain inputs, can we publicly see the outputs? So, like, implicitly, everyone in this room, we could play a game of Mad Libs and, like, say, like, let's say I shoplift right now. you know, I could be, that input can be thrown into one of these opaque algorithms, but I should, as a citizen, be allowed to see what the output would be in this sort of thought experiment. I'm wondering is anybody working on an idea around like sort of engaging some of these topics more individually and being able to go to a website and be like, what if I did X tomorrow or Y, and like what would that mean for me, to make it really personal? Because implicitly what these algorithms are saying is that we all have some kind of index, some kind of number that is associated with us even before we've committed anything. And I was wondering if, in terms of trying to bring, you know, if there's some research going around this to try to make this discussion more personal so that people feel connected to it and see, you know, some of the discrimination.
Yes, there's lots of research going on around this. I think one example I'll use that's a challenge with government systems is there's layers of law. So some of this information may be hard for a government to share because if they're blocked by FERPA or other like federal laws, then how do you know what information is being used? So there is a group of researchers that's working on a system of how to create comparable data that could be used for us to, like you as a person and consumer, to interrogate, but isn't revealing too much information that may, where a government agency would otherwise be violating some federal, state, or even local law. Yes, and thank you, I can remember. So that is one area that I think is really important, because I think that's one barrier that has to be addressed in order to have access to the information.
I would just add that there's another assumption I don't think we've spoken about, which is that the governments who are purchasing these tools themselves have audited them or done some inquiry into them that, I don't know, you'd get if you wanted a peer-reviewed article. And because that kind of inquiry is often not happening, and people are coming and selling these tools to government officials who are not always the most sophisticated consumers. And we often don't know what agencies have bought what in order to run their systems. We just don't know what is being run. And it's not as important in some cases to even have the algorithm itself, because what are you going to do with the equation? What we really need is what not law review, but what peer review articles would need in those studies, which is the training data or a set of the training data plus the algorithm, in order to really know, even if it is black box because of machine learning, what factors have been appearing for that algorithm and deciding what outputs it's producing.
One thing I will say very quickly, and politicians don't say many things quickly, I want you to know, but I will say it quickly, and the sum up is that we cannot assume that most people know how algorithms affect their everyday lives. They do not know the extent. And part of what we have to do is educate people about how data and algorithms really make decisions that affect them, how this involves them. This discussion is not a theoretical one. This is a policy decision that ultimately will affect everyone in this city. And people have to buy into that. They have to understand the importance of it. And that's a challenge. People are busy with their everyday lives. People don't know. People just know that they got a letter that they're not happy from a government agency. And do they really know how to pursue that and ask why and ask for the information? Many times they don't know what goes into those decisions. So therefore, it's incumbent upon us to be there for them through this process.
That's great. Can we make the next law should appoint or create a chief algorithms officer, and you should be the very first one.
No, thank you. Thank you.
Thank you for your service. We can't wait to see what you do and how you steer this legislation. Thank you for all of your time and energy. This is a very important conversation that has been happening for a while. We're so fortunate to be able to have it again this year. Definitely we need to have it again next year. So thank you for steering this. Let's give them a round of applause.